Today I would like to talk about the Malani United Oriental Insurance 923 versus W.M. Mazarol 1984. In fact, the vessel was taken out to sea by the respondent, and when returning into the river, the boat came into contact with the sandbar at the mouth of the river. The boat was grounded and could not be salvaged. The respondent claimed the insured sum of 40,000 from the appellant company, and judgment was given for him in High Court. The appellant company appealed.
The court held that the boat would be a constructive loss if the respondent could prove that her abandonment was reasonable and that on the date of the commencement of the action it was unlikely, on the basis of the facts that exist, that the boat could be recovered. In this case, both questions must be answered in favor of the respondent.
New Xiaomi Brother v. Road Transport and General Insurance Co. 1929. The applicant, a firm, submitted a proposal form to the defendant company for a policy on their bus. The proposal form, which had a basis of contract clause, was signed by a partner of the firm. But the answer therein was filled by the willie and agent of the defendant company. A policy was issued. When a claim is made, the defendant avoid liability on the ground that the proposal form contains certain untrue and incorrect statements. The matter is referred to the court.
The Court of Appeal held the insurer was entitled to repudiate liability since, in completing the proposal from Willie, had been acting as the agent of New Xiaomi Brother. Lord Justice Cruon set out the court reason as follows: if the answers are untrue and no is, he is committing a fraud which prevents his knowledge being the knowledge of the insurance company. In any case, we can escape from the consequences of his negligence by saying that the person he asked to fill it out for him is the agent of the person to whom the proposal is addressed.
In the suit, the appellants will plaintiff claim damage against the respondent for breach of contract. Both courts in India held that the contract between the parties was terminable by the respondent on reasonable notice, and that in the circumstances of the case 2 years, notice was a reasonable notice, and accordingly that the notice of 3 half moon by which the respondent had purported to terminate the agreement was not reasonable ban. Damage were awarded to the plaintiff on that basis. On a counter-claim judgment was given for the respondent. By act of parties, an agency under this heading may be terminated by unilateral revocation by the principal or unilateral renunciation by the agent at any time by giving notice. In Section 154 California 1950, in both situations, reasonable notice must be given. What would be a reasonable notice depends on the length of the relationship. The longer the relationship, a longer period of notice is required.
The court held is 3.5 months of notice that given by the P was not adequate to terminate the agency properly, which had lasted nearly 50 years. 2 years notice would have been reasonable.